All right, good morning. This is Attorney Vincent Davis. This is The Secret How to Fight CPS and Win. And I'm on with my special guest, Cassandra Woodard. Good morning, Cassandra. How are you?
Good morning. I'm doing good.
Okay. So we're live streaming today to about 8 social media platforms. So hopefully people will be able to tune in and watch this video, at their own leisure. Today's topic, we're not going to have a guest from the public. We're actually going to talk about how to prepare for your own CPS trial. Okay? Now, what I'm going to do is I'm going to talk about preparing for trials in a CPS courtroom generally. As the weekends go forward, I'm going to address each specific type of hearing, you know, um, by itself. But I'm going to give you some general information today, and hopefully you can use it with your lawyer. Now, I got to preface this. The things I'm going to tell you may or may not fit your particular case. Every case is different, and it's true. Every case is different. So these are just general rules that I use and I talk to my associates about using when we represent people in CPS cases. The other thing is, when I tell you these rules and guidelines aren't meant, let me repeat that, are not meant for you to do this by yourself. Okay? Don't try this at home. All right? Try it with your attorney and discuss it with your attorney. Your attorney may say, Davis is crazy. He doesn't know what he's talking about. Listen to your attorney, okay? Because they know more than I do about your case. All right. So I'm going to start off with telling you that it is extremely important for you to start at the end of your case and work backwards for the preparation for a trial. Okay. And the reason is that you have to know where you're going before you can develop a strategy. And to determine where you're going, you have to start at the end. What outcome do you want from this trial? Remember, every trial is different. All the issues are different. There are different procedural and evidentiary rules and different substantive rules in the law for every particular type of trial. So you got to figure out where you are and what you want at the end, and then work backwards. So generally speaking, I would write down number one, what you want out of this trial. Okay. And you have to be very clear and specific. Now, if you want to exonerate yourself of all charges versus if you want to win and get your child back in your home, those are different things. In most cases, you can't do both. All right. Sometimes you can, but you can't do both. So if you want to exonerate yourself and be right, we're going to go this way. If you want to if you want to win and get your child back, we're going to go that way. And today we're going to be talking about the latter, about winning and getting your child back or your children back in your home. Okay. So number one, after you write down your number one goal, I want my children back. All right. And you're going to write this: I will do anything that's legal, moral, and ethical to accomplish that goal. Okay? Because a lot of people that I talk to, they tell me, I don't agree with you, Mr. Davis. I don't want to do that, Mr. Davis. Mr. Davis, my belief system doesn't allow me to do that. And that's okay. I respect that. But you're asking me how to win. All right. I'm going to tell you. All right. But I'm not going to tell you this, that you're going to like everything I say. Because I already know, after dealing with thousands of cases over 35 years, clients don't like everything that I say. And, it's okay. When I was a younger lawyer, 10 years or less, that bothered me. Today, 35
Not
years
so
later,
much.
it doesn't bother me. I talked to someone today. This morning, if you can believe this, someone called me at 6 a.m. in the morning, Pacific time. They were in Pennsylvania,
Oh, wow.
right? And I listened to the story and I said, look, I said, I can already tell you what one of your major problems is. And she said, what? I said, you're trying to get CPS to understand your position and to be rational and logical. She said, yes, that's exactly correct. I said, but that's never going to happen. I said, now, why don't you focus on getting the kids back in your home? Because that's something completely different. And she thought about it, she like was silent for 10 seconds. And I said, is something wrong? And she said, I never thought about it like that. She's so busy trying to convince these social workers to see the world through her eyes that she lost sight of what she was actually wanted out of the case. The second thing that you should do is you should get all of the reports and minute orders together and put them in two different stacks. Reports on this side, minute orders on this side. Okay? And you should write out, without knowing anything about the law, write out what you want to tell the judge. That's the second thing. Just write it out. Now, I'm not asking you to write a story. As a matter of fact, if you write more than 2, maybe 3 sentences, you're not doing this the right way. Write out what you want. Judge, I want you to send my children home on the next court date at the trial. Don't tell me the reasons, because of this, because that, because the social worker is lying. Don't focus on that. Do social workers lie? Yes, they do. Okay, you're not going to change that. And the more that you try to show that and make that your primary argument, the less effective you're going to be inside the trial. Okay? Now remember, I haven't told you anything about the law or the evidence. These are just some preliminary things. All right? So once you write out what you want the judge to know or where you want to go, now you can start marshaling the facts and the law. Okay? The first thing you should do is read over every minute order. Okay? Because sometimes the judges order stuff that you didn't remember. Right? Or order stuff that you didn't hear in court. I have a lot of people tell me all the time, the minute order says the judge said to do A, B, C, and I never heard him say that. Or I never heard her say that. So review your minute orders. The next thing that you should do is you should read all of your social worker reports that you anticipate being admitted into evidence. And this is where you can help your attorney the most. Every report will be dated, okay? And every report will be numbered. You should go through each report and write down on a piece of paper the things that are false, okay? And you will say, report of December 22nd, 2021, page 7, paragraph 3 says, I slapped the kid in the face. Says, father slapped the kid in the face. You can write down, that is not true. I never slapped the child, and you should list what proof you have. Now, the proof could be a document or documents, or it could be a witness who was there at that day and time. Okay? And you make the list of your documents and your witnesses that could be used at the time of trial. Remember, it's could be used. I'm not saying would be used, because we're going to go from a universe that's this big down to this big in preparing for the trial. And if you don't start here, you're not going to capture everything. All right. But when you talk to your lawyer and you further analyze your situation, that list of witnesses is going to decrease, because you and your lawyer will know that perhaps that witness, although a possible witness, may not be needed. Okay. So you don't want to put on witnesses and documents to lose the trier of fact's attention. And the trier of fact in these cases, in most states, is a judge. I'm told that in some states, CPS trials can be in front of a jury, a modified jury, but yet and still they can be in front of a jury. But in California and in most states, it's a judge. So once you make the list of everything that it's right and wrong about your case, not right, but wrong about those reports, you're going to type that out and you're going to save it because you're going to be reviewing it with your lawyer. Because the witnesses that you do require, you're going to make a list, and it's going to be called the witness list. And it's a list that you probably will want to file with the court and serve on all parties. Same thing for exhibits or documents. And this is something that you will be discussing with your lawyer and, complying with the rules of this particular trial judge or county. Some counties and trial judges require exhibit lists and witness lists. Okay. Some don't. But I always find it good practice that if you make those lists so that you can use them as a roadmap when you're going through your trial. Okay. So once you do that, you're going to subpoena the witnesses, or your attorney is going to subpoena the witnesses and subpoena the documents into court. Now, here is the most important thing. The most important thing in any case is the story of what happened. Notice I didn't say facts. There's a big difference between a story and just facts. Story is a way to compel a trier of fact to be persuaded to your point of view. Story is a way to persuade. Facts are a way to bore someone. So you want to make sure that the story that you're telling, that it flows with your witnesses and with your exhibits. Now, one of the witnesses is going to be the social worker who wrote the different reports. And generally in Los Angeles County or in California, that's two people. It's the emergency response worker who wrote the initial detention report and the investigator who investigated and prepared what they call here the jurisdictional and dispositional hearing report. You might also want to consider subpoenaing in the services worker. Okay, that's the woman or the man who provides you reunification services while this case is pending. Because at the dispositional part of the hearing, the very end of what I call Module 2, that person will need to explain to the judge what services can be offered so the child can be returned to you. Okay? So that's three possible social workers. So that's how you're going to be subpoenaing in and making that witness list. Now, right now I'm talking about a certain aspect of the juvenile dependency case. Later on, and we'll cover these at a later date, sometimes there's only one social worker involved. And in some counties, and I've seen this happen, there's only one social worker. She or he did it all. Did the emergency detention report, did the initial jurisdictional and dispositional report, and provide you with services. It's unusual, but I have seen it happen. All right, so you got your witness list, and you've subpoenaed your witnesses, and you've subpoenaed your documents. Now, remember something. If somebody's on your witness list and you don't subpoena them, they ain't coming. And then when you get to trial and they ain't there, you got a problem. How many times has a witness told me over 35 years, "Oh, I'll be there, Mr. Davis. I don't need a subpoena"? Hundreds. Some people tell you that and something comes up and they can't make it. Some people tell you that and they have no intention of ever showing up at court. All right. So make sure that you and your attorney subpoena your witnesses. Sometimes you can serve subpoenas via email if they agree to sign for it via email. Otherwise, witnesses have to be personally served with a subpoena. Oh, there's another category of witnesses that you don't have to subpoena, and those are usually parties to the case, like the social workers. Your Honor, I want the emergency response worker ordered to be present. I want the preparer of the jurisdictional and dispositional report present. I want the services worker present. And the judge, 9 times out of 10, 9.5 times out of 10, will say they'll look at the county council and say, oh, you're ordered to have those witnesses here, or at least on 1 hour call. Cool, you're covered. All right. I've seen many trials where the parent's attorney needed to cross-examine a social worker, but forgot to arrange them to be present. How embarrassing, right? You could lose your case because of that. Recently, in the most recent years, I've noticed that if they're not present, judges will usually grant a short continuance, but don't count on the goodwill of that judge. All right, be prepared. Okay, so you're going to have your witnesses subpoenaed, and the same thing for your documents. So I'm going to tell you a rule that doesn't apply to social workers. All right, I said this rule does not apply to social workers. If you have a document and you want to introduce it into evidence, and what do I mean by document? Any piece of paper, any picture, any video, and you wanted to introduce into evidence, you have to lay a proper foundation. Okay? Now, proper foundation means that the person who prepared that document or the custodian of record of that document has to be in court to say, yes, Your Honor, this is a true and correct copy of that document. Give you an example. Man goes to court, father goes to court, and he believes he has a winning case. He says all the judge has to do is read the school records and the medical records, and I'm going to win custody. He goes to court, he loses, and he says the judge is corrupt because the judge would not even consider the documents, the school records, or the medical records. And the truth of the matter is that the judge is not corrupt. The truth of the matter is he didn't know how to lay a proper foundation to get the documents into evidence. And by the way, that's not the judge's or the clerk's job. That's your job to know that. You know, one of the the harshest rule I ever heard of when I was in law school is that ignorance is no defense. If you don't know the rule, shame on you. So, I didn't make that rule up, by the way. That's just a basic rule from English common law, and our whole system of justice, except for, I think, in Louisiana, is based upon the English common law. Louisiana, I think, is the only state based upon the French common law. So, if you have documents, you better make sure you and your attorney figure out how to lay that proper foundation. Otherwise, those documents are inadmissible hearsay. Now,
I see that a lot, though. Like people saying that, you know, I try to put this into evidence. I see that all the time on the comments. Like, I try to put this stuff. The judge never read any of the stuff I gave. The social workers never read any of the stuff I gave. And now I see why. It's because they're not laying a proper foundation.
Now, there is a way to overcome all of this by getting the social worker's attorney and the minor's attorney and the other parent's attorney to agree that your documents should come into evidence, even though you haven't laid a proper foundation. Does that ever happen? It happens. A little bit, not a lot. So be prepared to lay your proper foundation. Okay? I've had county council social workers who tell me that, you know, oh, Davis, you brought in the custodian of record to lay the proper foundation. Yes, I did. We'll just agree that, you know, they can come into evidence. Had I not had that person there, they would have said, "Oh, too bad, Mr. Davis. That's inadmissible hearsay,
Mhm.
right? You don't have your witness here. Too bad." But if I have my witness there and they want to save time, it's like, oh, okay, we'll stipulate to it, right? You see the difference, the subtle differences. All right, so you're going to lay your proper foundations. You're going to talk to your attorney about how to lay those proper foundations. The next thing you should do is something called discovery. Now, this you should have done this earlier on in the case, but it's not too late once the case is set for trial. And you want to send out informal discovery. And in your state, in California, it's dealt with in CPS cases in something called the California Rules of Court. All right, CRCs. You're allowed to conduct discovery in CPS cases. You're allowed to see all of the records the social worker has. Now, some of those records haven't been filed with the court. They're just in the social worker's file. And the other thing that you should be looking at, which will contain many times exculpatory evidence, meaning evidence that will help the parent, but are not submitted to the court, are the delivered service logs. Okay? So always consider looking at the delivered service logs. All right? Hold on a second. I have to look at something. Hold on a second, because
Okay.
okay, delivered service logs. Delivered service logs are the diary of the social workers for your case. They are nowadays typed and submitted via computer to the federal government, the Department of Health and Human Services, who actually conduct periodic audits on cases all over the country. You want to get those delivered service logs because a lot of times they do contain the exculpatory evidence, as I mentioned before, but they also give what I consider to be an insight into the social worker's thinking about the case and her supervisor's thinking about the case. So you'll have a better idea of what their concerns are when they recommend that the child shouldn't be returned to you. And it's very clear from most delivered service logs where they're coming from. It's very clear. And they may be addressing an issue that they really never even discussed with you. And you never knew why they were acting a certain way or saying certain things. Well, in the delivered service logs, it's explained. It's usually explained very clearly. Okay, Rachel has asked this question. How do you get a hold of service logs? Great question.
Mm.
First of all, you should talk to your lawyer about it. The second thing is you should Google discovery in a juvenile dependency case in your particular state. And when you find the rule or the statute, it will tell you exactly how to do it. In California, you can get a copy of the delivered service logs a couple of different ways. The first way is to have your attorney ask the judge to order it at any particular hearing. Judge, I like all the delivered service logs from the beginning of this case to the present day. 99% of the judges are going to say, okay, so ordered. And the social worker's attorney is going to have to give them to you. The second way is to prepare a discovery request pursuant to the California Rule of Court or the statute in your state. And you can just say, I want all delivered service logs from this date to this date. Make sure you're very specific about the dates, because that's a way for the social worker's attorney to object and not give you the delivered service logs. They can just say, oh, we didn't know which one she wanted. Did she just want the ones from yesterday or from last week or from last month or from the beginning of the case? So you got to make it very specific. Rachel, I hope that answers your question. Right? So once you get the delivered service logs, you want to read them. You want to think about them. And sometimes they may contain names of witnesses and telephone numbers of witnesses who you might want to call as a witness. And these are people that were never mentioned in any social worker report filed with the judge. So the judge doesn't even know of their existence. All right? So here's a typical delivered service log that might help you. I talked to witness ABC, and witness said the mother never hit the child. But that statement's not in the report. So the judge doesn't know that there's a person who witnessed the event and said that the mother never hit the child. Obviously, that would be somebody you would want to call into court as a witness. You see how that works, Cassandra?
Mm-hmm.
Okay. So in any of your case or case hearings, did you ever look at the delivered service logs?
No, but I plan to now.
Right. I bet you and most of the people watching didn't even know there was such a thing.
Oh, no, I didn't. And
Right.
I didn't know you could get them. And now I know how to get them. Thank
Now,
you, Rachel, for asking the question.
So when you ask for the delivered service logs, here's something else that you should ask for. You should ask for any of the personal notes and records and recordings that the social worker has. Because what a lot of social workers do is they go out and they take notes during their investigation. All right? Then they go back to the office, they look at their notes, and then they type them into the computer, into the delivered service logs. Now, between the typing and the writing of the note, sometimes all of the information doesn't get into the delivered service log, and sometimes it's information that is helpful to the parent, right? Social worker doesn't want to mention that part of the investigation. Okay. So you can be easily pencil whipped in a CPS case, easily, because the judge is relying upon the conclusions or the facts laid out by the social worker. And a lot of times assuming that the social worker is being 100% truthful and 100% accurate. Well, it's not true. Even if the social worker was being objective, the probabilities are that when she first heard the information from the witness and she wrote it down on her notes, there's going to be a disparity. Then when she takes her notes a day later or 2 days later or a week later, and she types them into the delivered service logs, there's going to be a disparity, right? And then from there, when she writes the report that she's eventually going to file with the court, there's going to be a disparity. It's just natural.
Like a game of telephone.
Right. And sometimes, Georgette would get upset if I said this. Sometimes those disparities aren't anything fraudulent or corrupt. They're just natural human tendencies. Listen, you and I do the same thing, right? And when we do something, we may think that it's not important at that time, right? Later on, it may become very important. And first thing we yell is corruption. It could be just mere human negligence, right? You
Yeah,
just,
I see that on like court TV things. Like I see that all the time. Like people have one story and then they go into court and then they have a different story and then they don't see that they're credible anymore.
right. Okay. Here's a question. This is an important question from Tiffany. Do they have a certain time frame at which they have to hand them over? The answer is yes. And if they don't hand them over, in California at least, you can make a motion to compel discovery. Now, here's a very interesting thing. In California, if the social worker doesn't comply with discovery requests, you can request sanctions. They can be in the terms of evidentiary sanctions. One of the sanctions that's allowed by law is that the judge throw the case out. So the sanctions against the social worker from not complying can be substantial. It's up to you and your attorney to try to enforce that. A lot of people say, she didn't give it to me. It's okay. We'll let it slide. No, don't let it slide. Because even if the judge doesn't throw the case out, he or she is going to be looking at that social worker a little differently. Like, you trying to hide something?
Mm.
Remember, our subconscious, of all human beings, our subconscious works in a very interesting way. And if we want to plant the seed of doubt about the social worker, not complying with discovery is usually one of the easiest ways to do it, because most social workers never, they're never asked for discovery. So they're like, whatever, not that they were trying to hide anything. They're just like, I'm not going to comply with it because Cassandra, is being an a-hole by asking me for it. You're being an a-hole because you're enforcing your rights under the law. That's how they view it sometimes, right? But you have that right. So remember, ask for the notes, the personal notes and recordings. Sometimes social workers record stuff that they shouldn't be recording. Oh yeah, I had a tape recording of that conversation. You did? Like, what happened to it? Oh, it's on my, my recorder. It's at home. I can't tell you the number of times workers have testified, oh yeah, I have notes, but my request asked for notes. Oh, I didn't realize that. I want to see your notes. Oh, okay. Right? What if she made certain comments in the notes? Thinking she'll never have to turn these over to anyone because no one will ever ask. Okay, so let's go on. So you get the delivered service logs. Now, here's something that a lot of people don't do, and this is overlooked. When you send out a discovery request, you should be sending it out to every person and their attorney on the case. So naturally, you want to ask the social worker. But the other thing you want to ask is the minor's attorney. Because most counties have minor's attorneys that have investigators, have their own investigators. And believe me, they find out stuff too. And do they ever want to, I guess, voluntarily share that with us? I've been involved in some cases where they didn't. I'm not saying this is a, recurring event because I don't know, but it's possible. So send your discovery request to the minor's attorney and also to the other parent's attorney, because sometimes, Cassandra, when you're in a case, the father of the kids, he's against you. He's joined with the social worker. So that person may have information and witnesses that you don't, that you want disclosed. And here's the important thing, okay? And I don't see this a lot, and it should be done more often. When I ask you for discovery and you give it to me and you tell me the witnesses, when the time of trial comes up and you pop up with a new witness, I can make a motion to exclude that witness because that person wasn't disclosed in discovery. Okay. Now, that doesn't mean the judge will grant my motion, but it is a possibility. And have I ever seen that done? Yes, I have. Have I ever seen it be successful? Yes, I have. Because the one thing most judges don't want is trial by surprise and you playing games and not disclosing your witnesses and your evidence. Okay? So that's why you want to make sure you ask for discovery from everybody else in the case. Now, that rule about discovery also applies to you if someone asks you for discovery. So don't hold back that witness, that's your secret witness. Okay? Disclose it all. And by the way, in 35 years of practice, I can tell you that it's better to disclose everything and not hold anything back as your secret weapon. That tends to backfire a lot, and I've seen it backfire on people. Don't do it. Disclose. Be an open book. Of course, with your attorney's advice, right? Because you don't want to be going around admitting, you're the one that killed John F. Kennedy, right? You don't want to admit to some type of crime or, something like that. So talk to your attorney again. Okay, Tiffany has a follow-up question. Does this include for protective supervision of disabled children, which was reported by a doctor, or is there a clause? I'm not sure clause. What I think she's saying is if you're a mandated reporter and you report something like child abuse, supposedly in most cases, that is confidential, but in terms of, I'd say there are ways to still get the information, and your attorney will know that, and you can speak to the attorney about that. Okay? But if protective supervision of disabled children social workers are using information and allegations against you, they have to disclose what that information is. Okay? And they have to be able to independently verify that. Right? They can't just come to court and say a secret witness told me blah, blah, blah. Because then there are constitutional issues regarding notice and the opportunity to be heard. So, those kind of issues come up all the time. It's something that you're going to have to discuss with your lawyer. Now, once you have that and the discovery completed, the next thing you want to do is you want to get an outline, not a transcript, but an outline of what you want to cover with each witness. Okay? Cassandra, you might want to ask different questions of the social worker versus different questions of your counselor. So the outline has to be just general, Roman numerals, capital letters and such, just topics. I've seen some very good trial attorneys in my career, and they use those, what do they call that app? The mind maps. You ever seen those? They're like decision trees. And
yeah, like they do the little bubble with the
right.
branching out bubbles.
And some of the best trial attorneys I've seen use that, and they have it on their iPad, and they're asking questions of the witness. They're not word for word questions, but they're saying, I got to cover this topic with this witness. Because sometimes in the middle of a trial and the heat of battle, you kind of space out and you forget, I was supposed to ask Cassandra about blah, 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 and I forgot. But with that mind map app or a checklist, an outline, you can just tick it off as you go through with each witness. I'm in the middle of a trial now, and I was asking a witness questions about a particular issue, and there was an objection, and the judge quickly sustained that objection. And I paused and I looked at the judge, and he said, "Is there something you want to say, Mr. Davis?" And I said, "Yeah." I said, "I was asking questions because blah, 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 blah." And the judge reconsidered, and he says, "Okay, overruled. I'm instructing the witness to answer that question." Sometimes people just know or believe they know what should be asked of a witness, but they don't know your strategy. right? Or they've never seen that done before with this particular type of witness. So your mind map will always remind you on what to do. The next thing that I think that you should do is come up with what I will call an opening statement. All right. The purpose of the opening statement isn't necessarily to read it off or spout it off to the judge at the beginning of the case. All right. Because here's why. And this used to happen to me a lot in CPS cases, 20 years ago. If you give an opening statement, especially as the defendant or the respondent or the parent in a case, you're going to basically tell your hand. And a lot of times the social worker's attorney or the minor's attorney will have time to rebut that argument or that witness. Okay. So if your opening statement, if you want to give one, and a lot of experts say that you should, it should be brief and not detailed because you're not dealing with a jury. All right. I could see it being done with a jury. But with an opening statement, you and your attorney are clear about the roadmap of where you're going and how you're going to get there. And you got to keep your eye on that roadmap as the case proceeds. Now, during the case, will there ever be any detours? Yes, there will. No trial ever goes the way you plan it to go. But at least you have a general map, all right? And the judge, believe it or not, who usually, is an experienced trial attorney, him or herself, they're going to appreciate it as well. Okay? So that's why I say, have that opening statement. Not necessarily to present it to the judge, but so that you and your attorney know where you're going. Okay? Now, I've worked from the back to the front, and now you have your way on how to prepare for a trial in a CPS case. Next week on Saturday, on our instructional Saturday, I'll go hearing by hearing and tell you specifically what you can do to prepare in each case. Today was just like a general overview. Okay? Mm-hmm. All right. Now, let me see. Did you have any questions, Miss Woodard, for me?
Actually, I do.
Mm-hmm.
When it comes to the discovery or logs, what if, will it be like of the CFT meetings too that have happened? And would it be what I said and what they said? Or could I even they're not recorded. Are they like the CFT meetings by the social workers or are they?
Generally, if they're recorded, they have to tell you, but there's always someone there taking notes.
Yes.
And generally, those notes are supposed to be input into the delivered service logs. They're a diary of what's happened. And I think in every CFT meeting I've been involved with, there's always a summary, right? Now, it might not be an accurate summary, but there's always a summary. Yeah. And you should be asking for that. And the first time you ask for it, they're going to look at you like you're crazy. Like, nobody ever asks us for that. That's probably true. But the law is you can ask for it. And if you do ask for it, they have to give it to you. I once attended a CFT meeting many years ago. And the social worker said, well, Mr. Davis, you're not allowed to be in this meeting. And they wanted to exclude me. Subsequently, in the civil lawsuit for civil rights violations, that issue of depriving a person of an attorney at a CFT meeting was acknowledged to be a violation of your constitutional rights. You see, whenever you have intervention or interaction with a governmental entity like
Mm-hmm.
CPS or the police, you have the right to have an attorney present. You have that right.
Yeah.
It's America, right?
Mm-hmm.
So for them to tell you Mr. Davis isn't allowed is either number one, ignorance of the law, because this never happened before, or number two, just an outright violation of we're going to take advantage of Cassandra without Mr. Davis being there. So F Mr. Davis. You got it?
Mm-hmm.
Okay. So yeah, they're always summaries. Okay, here's Autism Mama says, we're getting ready to go against DCFS for some crooked stuff, and I'm having to try and be a lawyer. Autism Mama, that ain't a good strategy. I'm sorry to say this, but it's not a good strategy unless you're a lawyer yourself. But if you're not a lawyer, you're about to swim with the sharks. These people know what they're doing. They're highly trained. They get the best legal talent they can that money can buy. Don't think these people are slackers and don't know what they're doing. They know exactly what they're doing and they're expert at it. And they do it every day of every week, of every month, of every year. And this is probably your first and only case. So you're going to be outgunned. Autism Mama, I suggest you find a lawyer in your area to consult with, or you can either consult with me. You can give me a call. There's the telephone number, bottom right on the screen, 888-888-6582. All right, Joanne says, thank you. Okay, here's Tiffany. We have a dependency trial. It is to be in front of a magistrate. So already I know Tiffany's not in California. She has also shown bias. My court-appointed lawyer stated I couldn't have her recused. That's an interesting opinion. I mean, I don't know what state you're in and what the laws are, but I'm aware that you can always try to have a judge recused if there is substantial facts to support your position, even though she has a personal connection to the CPS worker. Okay, so, Tiffany, I don't know what state you're in, but if you were in California and the judge had a personal connection with the CPS social worker, the judge would be off the case and would naturally recuse herself and send it to another judge, and or the CPS worker would be taken off the case. A former client contacted me, and we brought a civil rights lawsuit against the social worker. And we recently found out, and I have to say, we found out late, too late, although we did settle the case favorably, that the CPS social worker was dating, then got engaged, and then got married to the father in the case, who was against us. But apparently, according to social media, because my client had been stalking them on social media, she went back and found a picture of the social worker sitting in the father's mother's home. And the picture said, "My future daughter-in-law." Can you imagine? And this was during the case. So you don't always get to find out everything, or maybe you should be digging much deeper. All right. Rachel says, will this segment be on replay? Yes, it will, Rachel. It will be on replay. You can watch it on replay on the Facebook page you're on, or another Facebook page, or on YouTube on my YouTube channel. I think it's called CPS Defense Strategist, or just go to YouTube and search my name, Vincent Davis. Mm-hmm. All right. So we've come to the end of the show. And anything else you want to ask or add, Cassandra?
No, right now. Maybe in a different show because I can't think of anything right now. But I'm going to rewatch this again,
Okay,
and I I'll probably ask you on Monday.
no problem. But Grace, our producer Grace, I think is still there. Um, Grace, we're going to have a show tomorrow.
Oh, we're
9.
having a show tomorrow.
Yeah, we're going to have a show tomorrow, 9 a.m. Um, Sunday morning.
Uh-huh.
And I think Grace is off on Sunday, so we won't be able to have her. I think I might have to do this all by myself. But Grace, today, if you can do it something before you leave for the day, can you find us a couple of guests for tomorrow? So if anybody watching wants to be a guest, please email Grace at vincentwdavis.com. Grace at vincentwdavis.com. Okay? Thank you again, everyone, for watching. Have a good Saturday, rest of the Saturday. And Cassandra, thank you for joining me.
Mhm.
If you can join tomorrow, that would be great. If not, I understand. But otherwise, we'll talk to everyone later.
Okay.
Bye bye.
Bye.